Plex. Yeah, I think everyone heard it, recording in progress. So this is the last warning. But I think the recording is very helpful because we had many requests for all those who cannot join us. And I think, as we said in the invitation, it's really a unique chance, I think, because we have Martin Giersch here, who not only knows about all these things, but also negotiated it. I think a lot of the understanding of this fairly complicated guidance, I think, lies also in its history. But before we start also with Priska, who will give us an introduction into the differences between Espoo and Aarhus and lifetime extension complaints we made in the past year, usually with Priska's help. I wanted to look back into the year 2014. Most of you know this. This is when Ukrainian NGOs complained to the implementation committee of the Espoo Convention that Rivne 1 and 2 units were lifetime extended without environmental impact assessment. And I think most interestingly, the implementation committees, those famous professors who know it all, they said, yeah, actually it should have happened, but it didn't. And then we were at the mob, and that's where they almost started fighting. I have to say, I haven't seen delegates like that, because obviously the nuclear countries fear this would be very dangerous, which I'm not so sure is the case at all. But anyway, so they kept fighting 7 years against having it confirmed that there is a duty to conduct environmental impact assessments also for lifetime extensions. And in the end, they agreed on this thing that's now called the guidance. And using it is not that easy. That's why we're holding this webinar. What I wanted to add is, Gabi, can you show quickly? I have one slide, and this is because on top of that, of course, having an environmental impact assessment is a chance for campaigning, because it's the first time that some nuclear power plants might be put into question. You could raise the issue of alternatives. So it's good for campaigning. But as you know, one of the most important policy decisions ongoing still is the EU taxonomy, the financing of so to speak, green investment. Energy plays a major role. And we are now in the situation that the so-called complementary delegated act, it's not yet adopted. We're waiting and hoping for the European Parliament to stop it still. But anyway, the status is that nuclear energy would be in as a transitional, but still in the end, of course, it would receive a certain green label, and in the end also financing. It took them a while to find out how nuclear could be in the taxonomy. So it actually says only these three points. On the one, that is a transitional activity, and then you have this 4 to 6, 7 and 8. And this is the last point that we're actually discussing here, is nuclear energy in existing installation, meaning it's Plex. Yes, so I think starting not now, but next year. So those works undertaken can be labeled as investments under the taxonomy. And this is really interesting, because until now, this is also what this whole webinar is a little bit about. The countries tried to argue, this was a normal investment, routine maintenance. This was not a preparation for lifetime extension, because they tried to avoid environmental impact assessment. Some very smart ones even changed the nuclear law, and having only unlimited licenses. The Czechs, of course, for example, did that so as to evade it. And now they would have to go the other direction. So we're looking forward to this. But in any case, it would be very important, of course, to demand that environmental impact assessment is conducted for any measures they might ever use under the taxonomy. So that's why we look at the possibilities, which situations, as it's called, which might trigger environmental impact assessment. I think it's time if we would ask Priska Luega. She works as an environmental legal expert with the Öko-Büro. She's been very active on lifetime extensions and nuclear. She helped us with many cases, also, for example, Dukovany, where we already have the response, and under the Aarhus Convention, of course, there would have been necessary environmental impact assessment, but I think she will tell us about this. Priska, if you want to start.
Thank you, Patricia. I will start sharing my screen, if this is possible. Wow. Oh, no, I think this is again.
No, could you
Can
use
you see it now?
Yeah, but could you use the other? Yes, this is better. Thanks.
Yes, it always takes a while to find the right setting. So good afternoon, everyone. And welcome to our webinar also from my side. As Patricia already said, I would like to talk with you about the different legal tools and frameworks for public participation when it comes to the lifetime extension of nuclear power plants. Just to give you an idea about my background, I'm working for Öko-Büro, which is the alliance of the Austrian environmental movement. And we have currently 20 member organizations who are all environmental NGOs from Austria, including Global 2000 and the Austrian Institute of Ecology. So Gabriele and Patricia, who are organizing this webinar today. And we mostly work on legal and political level with a focus on the rights of civil society. And Öko-Büro is also a member to the European Environmental Law Network Justice and Environment, or JNE. And yes, together with our member organizations, we usually bring different cases to court, but also to the international fora. So for example, together with Global 2000, we had the case regarding Dukovany, but also regarding Slovakia before the Aarhus Convention Compliance Committee already. And today I would first like to give you a little bit of an overview what regulatory frameworks are applicable when it comes to public participation regarding nuclear power plants, and then especially give you a little bit of a distinction between the Espoo Convention and the Aarhus Convention, because I think it's very important to know what rights are included for the one convention and what rights for the other. And then I would like to talk with you about the definition of lifetime extension within these different regulatory frameworks. And afterwards, specifically talk about the rights of the public within the Espoo Convention, since this is the main focus of this webinar today. And finally, just introduce the main steps of a transboundary environmental impact assessment procedure according to the Espoo Convention, and then also present to you a little publication we recently had from Öko-Büro side regarding public participation regarding the lifetime extension of nuclear power plants. So these will be the 6 parts of my presentation. So first of all, the regulatory frameworks, they're mostly, the most important ones are the 2 UN conventions, the Aarhus Convention, which concerns access to information, public participation, and access to justice in environmental matters, which is mostly focused regarding the governments of the countries where an activity takes place, but it also has some transboundary aspects. And then there is the Espoo Convention, which particularly focuses on the environmental impact assessment in a transboundary context. So it's the procedure between different states. But both conventions apply to nuclear power plants and their lifetime extensions. So they're both important when it comes to public participation. Yes, and finally, for EU member states, there's also the Environmental Impact Assessment Directive, which also transposes the Aarhus and Espoo Convention to European law. So for European member states, basically the Aarhus and Espoo conventions are both applicable from both sides. So on the one hand, from the international perspective, but also as directly applicable European law. And then there is also other European legislation, which might be important when it comes to lifetime extensions. For example, regarding the Habitats Directive, or there's also the Nuclear Safety Directive, just to give you an idea that there, for specific other topics, other regulations might be applicable as well. So, yes, so when it comes to Espoo and Aarhus, we have on the one side the state of origin, which is the state where the activity or the nuclear power plant is located. And then you have on the other side all potentially affected states. So they can be direct neighbors to the state of origin or also further away, because since we know that, especially when it comes to nuclear power plants, there might be further reaching environmental impacts. For example, when we had the nuclear power plant Hinkley Point C in the UK, even Austria, which is quite far away, was an affected state in this procedure. And so when we have a focus on the state of origin, you see these blue arrows because the public in the country of the state of origin, but also in all potentially affected states, has rights towards this government of the state of origin. And when we have the Espoo Convention, it has a more transboundary aspect. So it always needs this factor that it's from the perspective of another state. And so if you're part of the public of an affected state, you can contact your Espoo contact point, which is located with your own government. And I've included a link here, so you can, afterwards, when you receive the slides, you can access the list of all national Espoo contact points. And the government of your affected state then gets into contact with the state of origin. So this is also something that's regulated by the Espoo Convention, this relationship between the government of the state of origin and the affected state. So it always needs this transboundary factor when it comes to the Espoo Convention. And regarding Aarhus, you have the direct rights concerning the state of origin. So I hope that made it a little bit more clear. And now why it's also important to differ between these two different conventions, not only because their parties differ in some details, they also have different perceptions of lifetime extension. So as Patricia already mentioned, within the Espoo community, there were quite some discussions which cases of lifetime extensions actually fall under the convention, until they finally reached the consensus to define 4 different scenarios. But I won't go too much into detail here because Martin Giersch will talk about these different scenarios afterwards and their technical aspects. Whereas the approach from the Aarhus Convention is a little bit different. So they just say that when the lifetime of a nuclear power plant is extended, public participation must take place, mutatis mutandis, and where appropriate. So for example, regarding the NPP Borsele, we had the decision that the extension of 10 years. Yes. Patricia, can you maybe read it? So the extension of 10 years of the NPP Borsele led to the fact that the public participation requirements had to be applied. And then there's also a decision that periodic safety reviews fall under the Aarhus Convention. That was recently decided within the Dukovany case I already mentioned. So since then it is clear that under the Aarhus Convention and the Aarhus Convention requirements must also be applied where appropriate when it comes to periodic safety reviews. Yes, and then also the European Court of Justice already published one judgment regarding the lifetime extension of the Belgian nuclear power plant, UOL. And there it said that the extension of the lifetime by a significant period of 10 years, combined with major renovation works, led to the fact that an environmental impact assessment had to be conducted. And there are also tendencies on European level to say that also only this fact of a lifetime extension without major renovation works already leads to the fact that the EIA directive must be applied. But this is still part of a running case, so it will hopefully be decided soon. Yes, and then if we now take a look at the Espoo Convention in particular, there are different rights of the public, so of NGOs or also individuals who want to get involved. First of all, regarding the state of origin, the state of origin has to inform and involve all potentially affected states in the assessment procedure. And an environmental impact assessment has to take place when all options are open. So at a very, like the most early stage as possible. And comments and objections must be reflected and taken into account in the final EIA decision. And as a public, as I already said, you also have rights towards your own state government, which might be the affected state, to enter into the transboundary EIA procedure if environmental effects are likely. And this also includes effects from potential accidents, which is very important when it comes to nuclear power plants. And the affected state then has to publish documents in an easily accessible way. And the public in the affected state has the possibility to submit comments, which are then forwarded to the state of origin. And of course, as a public, you also have the right to be informed of the proposed lifetime extension, and there have to be translations if necessary. And reasonable timeframes must be provided to submit comments and get involved. And if these requirements are not met, there are usually legal remedies on national level. And there's also the possibility to submit the complaint to the European Commission or to the Espoo Implementation Committee, as we did, for example, together with Global 2000 regarding the Dukovany lifetime extension. And this case is still pending before the Espoo Implementation Committee. So now there's just one slide regarding the transboundary EIA procedure. So it all starts with informal contacts between the state of origin and potentially affected states. And then the party of origin informs the states, other states officially of the planned lifetime extension. And as a next step, the affected state must inform the state of origin if it wants to participate in the environmental impact assessment procedure. And if it does so, the party of origin must provide relevant information to the affected state. And the affected state then notifies its own public of the proposed activity. And this is when the environmental impact assessment can start. And the public, on the one hand, of course, in the state of origin, but then also in the affected states has the right to submit comments and participate in the procedure. And finally, these comments are transferred to the party of origin, which then announces the decision taking into account these comments received. So this is just a brief overview of the procedure. And then, as I already mentioned, we recently published a toolkit on public participation, especially with a focus on lifetime extension of nuclear power plants. And I have provided the link here to this document so you can access all the information I just talked about in a more detailed way. Yeah, so thank you very much for your attention. And yes, I think in the end you will have the possibility to ask questions if anything is unclear.
Yeah, Priska, thank you very much. Before I forget it, I'm sorry, something I wanted to say before. Also, because you said we're expecting Dukovany will be decided soon also from Espoo, and we fought a lot over Aarhus. What's really, I think, underestimated often, you really need to collect also a lot of information about the measures and the modifications they are undertaking with their plans. So it's not enough to say then, to write a letter and say, we think they lifetime extended and we are so sad about it, please do something. It really needs really a lot of information. The NGOs also have to collect on what's happening, how much it costs, what kind of technical modification. So with Dukovany, for example, we had a lot because I researched all the modernization programs and they exchange a lot, but I think this is underestimated very often. So this is a little warning.
Yes, and maybe just to add on to this, it takes a lot of years. So if you're filing a complaint, you have to expect to be contacted again, even years and years after, and submit further information and updated information on legislative changes in the countries, etc. So. Yes.
Yeah, therefore, I think now that we're at the practical part, it also proves very good to have, of course, support like from Priska, of course, someone who did it before, or at least to have 2 or 3 NGOs, or at least 2 or 3 experts who are able to work on this, because it can drag on for years till the implementation committee really takes a decision. Okay, and now it gets really difficult. Now we have Martin Giersch, who works for the environmental agency in Vienna. And as we said, already negotiated also the Espoo Guidance on nuclear power plants in case of lifetime extension, and will try to explain to us how we can use this splendid guidance from now on. Martin.
Martin, du bist noch stumm geschalten.
So I hope now it's running. You can see everything and hear me? Thank you. Thank you for introducing the topic already. I will provide you a short overview about technical background for the applicability of the Espoo Convention based on the guidance and some experience from the development of the guidance, where we were introduced also. My name is Martin Giersch. The work was done under the Environment Agency of Austria. My talk consists of 2 main parts. The first 3 bullets are on the technical background. We will not go into the details, but it is necessary to have a general understanding of the concepts and principles, because they are used for the second part for the situations. There are 5 situations established by the guidance and agreed by the contracting parties to classify real cases of lifetime extension, if in which extent the convention can apply. Later on, some key points. Let's go directly into the technical sphere. An old nuclear power plant, there are 2 main issues which are quite challenging. One is the aging of the NPP, described by the physical aging of the structure, systems and components. So you can, on the right side, you see an example of a lower part of a pressurizer of a Khmelnytsky nuclear power plant, you see some corrosion, which is a typical phenomena of physical aging. There are other aspects, for example, from irradiation of neutrons and gamma radiation, heating and cooling, pressure, in principle, material degradation. And even if the nuclear power plant is not in operation, all the structure, system, and components are aging, and earlier or later it is necessary to prove if they can fulfill their original design conditions for which they were designed and constructed and proved. It's a safety issue. During the plant operation, for the whole period, you have to assure that all structure, systems, and components can fulfill the conditions. You have to maintain and to refurbish systems. And if this is not possible, in some cases also to replace. There are several safety critical systems in the power plant, which are usually every year or every 10 years replaced. This is a common issue. But there are also safety critical systems which can be not replaced, the reactor pressure vessel, for example. And these are critical structures. We will come later on to that point. So physical aging, one major issue for an old nuclear power plant. The second one is obsolescence. Even if the power plant is maintained and refurbished in a quite good condition, and it is as good as new, after 40 years, it's an old-timer, in a good shape, but it's an old-timer. On the right side, you see again two control rooms. The upper one is a more or less state-of-the-art control room with a digital INC system. The lower picture is a control room from technical status from the 80s. Both are in fine conditions, but there is a difference, and not only on the surface, it's also behind. And so it is necessary to address also the obsolescence. We can call it the aging of the safety concepts behind. There's a progress in science and technology, which is reflected then also in the technical products and also in safety requirements. For new nuclear power plants, usually are the safety requirements and the licensing basis is more strict than for old ones. This has to be addressed. Usually there is one licensing basis for all, but in fact, for the old nuclear power plants, it is not applied immediately or only if there are arguments that it is necessary to apply. An old nuclear power plant, you could usually not authorized under the state-of-the-art licensing basis. I refer to two main legal international documents. One is the Euratom Nuclear Safety Directive, which requests for every 10 years a safety review, so continuous safety reviews in a continuous cycle, and then also based on that, continuously improving nuclear safety, taking safety requirements for new nuclear power plants as a reference. And the other is more in the international sphere for IAEA or for the conventional nuclear safety contracting parties. The Vienna Declaration, it was applied as a lessons learned from Fukushima in 2015. Also here we have safety improvements for existing nuclear power plants, and also here it is addressed that the safety standards for new nuclear power plants should be taken as a reference, even if you cannot reach it. So there seems to be a difference between safety of new nuclear power plants and existing ones, and it is also addressed as a problem. Safety, not only for lifetime extension, but for aging and obsolescence, always it is necessary to prove the fulfillment of the main safety objectives. These are the three main safety objectives for all nuclear activities, not only for lifetime extension. First, criticality control. So to control the chain reaction for the nuclear fission, which is producing heat, which you later on use. Second is the heat removal. Usually you use the heat in your processes for electricity generation, for example. But also if you shut down the nuclear reactor, you will lose sufficient power from the criticality, which is about 90% of the heat production. What you cannot switch off is the decay heat from the radioactive decay of the radioisotopes. This about 10% are remaining and you cannot switch off. So for a considerable long period, it's for at least about 3 years, you need to cool actively the spent nuclear fuel and to remove the heat by a flow of water or air. And this is absolutely necessary to assure. And the third, perhaps the most important one, is the containment integrity, to ensure that no radioactive particles are going into the biosphere, into the environment. The third one you can only ensure if the first and the second one are implemented, because otherwise, if you have too much heat production, you will have a core melt, and earlier or later you will lose your containment function. So this is just a major, these are the main safety objectives for nuclear power plants, also applicable for lifetime extension. Quite short technical terms. Sometimes there are different technical terms in regard of lifetime extension or long-term operation. Going into the detail, there are main differences. You cannot exchange these expressions. Nuclear proponents frequently use LTO, long-term operation. It sounds a little bit the same like LTE, lifetime extension. For long-term operations, it's just continuing without declared extension. You don't know in which licensing or plant state you are. Lifetime extension, which is used also in the Espoo Guidance, is directly fixed to something to extend, which is a design lifetime. Now, there was a lengthy discussion, and it is in principle also not totally finished. There is no common understanding how to define design lifetime, because it's a licensing issue, and therefore under the responsibility of national nuclear safety authorities. Yeah? But it was possible to find common elements to get a picture, an understanding of a design life, and therefore then also for the design life extension or lifetime extension. Now we're coming into practical application, keeping in mind a little bit this technical concept and background. Under the Espoo Guidance, 5 situations were established and agreed by the contracting parties. The first one is more or less clear. The end date of a time-limited license has been reached, but the plant is intended to continue operation. This was the case for the Rivne, or following EIA nameplate Rovno 1 and 2 case. They had a limited operation license for 30 years. This was extended. So under our Espoo understanding, it would be necessary, or it was necessary, to have the possibility of environment impact assessment under Espoo. This is a rare case. Usually there is no time-limited license. But at least we have one case necessary to consider, and is classified as a candidate under Espoo. Situation 2, the nuclear power plant has a time unlimited license, but the design life of irreplaceable safety critical structures, systems and components has been reached. Sounds complicated, is quite easy. For the whole power plant, there is no time limited license, but looking more into the details, two main components. You have, of course, a licensing basis, considering also an operation lifetime. This also depends on the warranty of the vendor. If a vendor sells some components, he has to assure that the components fulfill safety objectives within a limited time. And of course, this is also a part of the contract. Maybe it's not an open issue, but in principle, it is absolutely necessary. It's even if you buy a vacuum cleaner, something like a warranty is applied. Now, if this time-limited license is over for some safety critical components, even you can proceed if you can replace it. Problem is if it's irreplaceable components. There are not so many irreplaceable safety critical structures and components. One is, for example, the reactor pressure vessel. There was so far no case for a commercial nuclear power plant where the pressure vessel was exchanged, substituted by a new one. You would have to build, in principle, a new nuclear power plant. But other major components, something like steam generators or pumps or pressurizers, they were removed. We have seen already some pictures. If an irreplaceable component reaches its license, the design life, then it's necessary to apply for a lifetime extension for this component. And this means also it's an application for a license extension for the whole plant. Yeah, this is so it's not always necessary to look only on the whole entire plant, also to look on safety critical systems and components. To be said, this is a common case. Yeah? This is a common case, and perhaps it has also to be addressed here. If we have a new license, then in principle also new license conditions should be applied. Not anymore the conditions 40 years ago, but we should consider safety requirements, safety standards from state of the art. And this has also an influence to all other systems which are not under new license. Yeah? But we should keep this in mind, and in principle should insist on that. Situation 3, a periodic safety review is carried out in support of the decision-making process for a lifetime extension. Usually for NPPs, every 10 years, this is the international practice, a periodic safety review is applied. This is going into all the technical details and looking to the systems. Will they sustain for the next 10 years? Under license conditions, are they safe enough? Yeah, is it possible to extend, in principle, something like an operation permit for additional 10 years, even if the license base is unlimited? The problem here is to address in the process of lifetime extension. There could be someone say, yeah, we proceed for 10 years, and for a periodic safety review every 10 years, it's not necessary to make an Espoo procedure. And there were so many PSRs, look on the 130 plants in Europe, and so about 10% of them every year have a periodic safety review. Why to make an Espoo procedure? Here, the clue is really to look on the in the process of a lifetime extension. So again, necessary to know about originally plant design lifetime or project lifetime, usually 30, 40 years. French nuclear power plants, the VD4, the fourth PSR, is a case here. This is a quite common case. Situation 4, modification of a nuclear power plant not covered by the existing authorization to operate and therefore requiring a license modification. Interesting point. The 3 situations before, they could sustain even without physical work on the plant. You do some refurbishment perhaps, but it is more a legal or licensing issue. Here you have really modifications of a nuclear power plant not covered by the existing authorization. So for example, power increase or additional safety upgrades, switch to another nuclear fuel with another period of refueling, something like this. So you have here 2 points where Espoo can apply. One is physical works, and perhaps also something like a major change, if you have really to construct something major. And the other issue, if you need a new license because the old license cannot cover the new issues. And also here you can call, okay, it's so a new license is again also is a license decision. And also you may apply now the state of the art, the current safety standards to the whole plant. Situation 5, quite clear and with only few technical background. The nuclear power plant is a time unlimited license, but the time of operation is limited by law. It's a hypothetical case in that if Germany, for example, now would decide to proceed with nuclear power, the original license was not finished. It was restricted by law, yeah, and then you have a new law. It's a new decision, and then of course also Espoo should apply. I have to underline that this situation, they may filter candidates which may apply, but it depends then really on the situation, how you can argue, and we don't know currently, for example, for the 32 French 900 megawatt PWRs, which are now in the phase of, in principle, of periodic safety reviews under the scope of lifetime extension, it will really fit into an Espoo procedure. We don't know. And also a lot of physical work was already done. Yes, for about half of these units, the steam generators, for example, we have seen before some pictures, were already replaced. This means about such a steam generator is a safety critical system, is the largest component which you can replace. One of them is about 380 tons. And there's a value of about 50 or 100 million euros. It is already done frequently. Yeah? There are more than 20 steam generators already replaced. It's more going to the direction of 30 without any Espoo procedure until now. Just the key points in a short combination. All structure systems and components are designed to fulfill technical limits and conditions during a design life, even if the plant itself has no official design lifetime. Each component has. For safety analysis, loads from normal operations in the expected event are defined. So you have a licensing procedure behind, which argues the design life, and you need an argument to extend it. With in-depth plant inspection, lifetime extension may be possible. And there are these 3 issues: maintenance for the existing systems, physical repairs, refurbishment, or replacement. In most of these cases, you need a requalification. This was a hot point in the discussion, in the technical discussion for the Espoo guidance, because the requalification is something like a basis for new licensing. And here we have a decision by a competent authority, and here we can come with the Espoo case. And we can say this is a decision, even if nothing is done, it's a requalification of the same reactor pressure vessel, and it's a decision. So now it is necessary to apply the Espoo Convention, and also it's necessary to apply the state-of-the-art safety requirements, the new limits and conditions. Requalification of equipment is independent from, but may imply physical work. What I said already now, it is based on certification and agreements for warranties and liabilities. Someone should say the reactor pressure vessel can remain 10 years under the license condition. Someone should take also the economic responsibility and should make a certificate for that. With requalification, the actual safety requirements, as for new NPPs, has to be applied for authorization. And this, in our opinion, not only for the part which is requalified, but then really also for, more or less for all safety critical systems to apply actual safety standards. And this is a lot of work to fulfill. And the authorization of plant operation is based on legal decisions and may trigger an Espoo procedure. Because some countries call it license, some authorization, some permit. We should not look into to split too much. The intention of the decision of a competent authorities is a major issue here, and this should be a trigger for the Espoo procedure. Just at the final stage, also to underline, we have in principle the nuclear issues, which are under the competence of the Nuclear Regulatory Authority and which are a black box for the environment issues. But for Espoo, which is an environment convention, we should go into some technical details. Otherwise, we have no triggering point how to apply the convention. It's just a black box. We should go into a little bit more into the nuclear issues. We should perhaps without interfering there. We are not requesting the authority of the regulator, but we need to understand what the authority is doing to understand the implications for Espoo. Thank you very much.
Yeah, thank you very much. I think it was a really excellent overview, and there are many aspects I think which are very usable when we look at the nuclear power plants we might be campaigning on. So perhaps I think it was a lot. I would ask, are there any questions, something you have perhaps not understood before we continue with two more presentations? Of course, we come back to these two, but still, are there questions? Tony, please turn on your sound. Yeah.
Well, often it is mentioned that some authority or some expert institution is issuing a certificate for some piece of critical equipment that it is in a functional order or that it is safe for operation. Obviously, that is not issued by, I presume, regulatory authority of the country, because it should be issued by some technical institution with expertise for certifying technical equipment. Which are those institutions, and do we have some sort of European criteria for those institutions which they have to comply with? So if I ask my authority, is nuclear power plant Krško having certificates for all critical elements of equipment checked and issued proper certificate, could I ask or should I expect that some sort of conditions that institution which is issuing certificates is complying with, like, standards for technical expertise or whatever? I'm not sure, am I clear enough?
Thank you, Tony, for this question, which is quite useful. In principle, it is quite complicated going there into the details. Some of the certificates are done by the vendors itself. of course, then there are institutions like, for example, TÜV Süd, which has the certificate to make certifications. And then also the national authority should accept or can prove, is the certificate correct? Yeah. So there is a chain of qualification. And also usually the nuclear authority is not doing this technical analysis by themselves. They have also some institutions with some expertise to check. Yeah? So the operator or the vendor is doing it, and the regulatory authority is doing it again with an independent institution. And it's a complicated process. I'm not familiar on the dimension how much is already established in this certification business on international level. There are at least there is a national competence to provide to institutions that let's call it certification, that they can do their job. Yeah? But if they are from another country, I don't know how they can apply for that. Should be checked.
Okay, anything else for now? Okay, so then we can continue. We have now Jan Haverkamp, who is, I think, in these circles very infamous because he followed up many of the Plex cases with Aarhus already. Jan, are you here?
Yes, I'm there.
Yeah, okay, great. So you can speak for yourself. Usually I'm not worried about this. You will show us, I think, the interesting about maybe, for example, this Borsele case is that, as we said, it takes a while, but somehow there is always some progress. And it's, of course, the issue also of precedents. And I think you already produced a lot of precedents in this case, so please.
So I would like to tell you about two cases that I have been or am still involved in, which have a lot to do with setting precedents. The first one is the Borsele nuclear power plant in the Netherlands. Borsele reached its 40th anniversary in 2013, so it's already a while ago. It has an initial technical lifetime of 40 years, so that point was reached in 2013. In the end of the 1990s, the Dutch parliament decided for closure in 2013. But after privatization of the nuclear power station, the government agreed in 2006 with the owners of the power plant on a lifetime extension until 2033. That needed an adaptation of the operation license, and that was happening in 2013. Greenpeace Netherlands appealed against this adaptation of an operation license for the lack of an environmental impact assessment on the basis of Dutch law, the EU directives, Espoo and Aarhus. It was not possible to appeal against a gentleman's agreement from 2006. So the only possibility that we had was to appeal against the licensing decision, which came in 2013. After we lost the appeals at the Raad van State, the Council of State, the upper administrative level, Greenpeace informed in 2014 the Espoo Convention Implementation Committee. That was shortly after it had reached its findings on the Rivne 1-2 case. The Espoo Implementation Committee is still investigating the issue, and in my presentation, in my presentation, you can also see the number, and in my written presentation, there's also a link where you can find the documentation. Greenpeace filed also a communication to the Aarhus Convention Compliance Committee in 2014. The ACCC, the Compliance Committee, came with its findings in 2019, and there it found that the Netherlands were in non-compliance with the convention for the license change in 2013 because it did not have public participation on the environment. It also stated, it based itself on Article 610 of the convention, which is the article that speaks about extensions and updates of activities. Nuclear power is an activity in Annex 1. And if you have an extension of that activity or an update, you have to provide for public participation under Article 6. Mutatis mutandis, that means with all the changes that have happened when appropriate. And a lot of the discussion turned around the term when appropriate. Was it appropriate? Is a lifetime extension decision, as in 2013, an appropriate moment to have public participation? The Compliance Committee also concluded that yes, it was appropriate to do that here, but in principle, it should already have happened in 2006 before the covenant, the gentleman's agreement, when all options were still open. But because it hadn't happened then, the license decision in 2013 had been taken in non-compliance with the convention. It then gave also advice, and in its advices, it proposed changes in the legislation for cases of the duration of the operation. So that means that if there is another lifetime extension in which the operation time of a nuclear installation is changed, it should be clear in the law that that there should be public participation. Now, there were new changes in the license in 2015 and 2018. That was still during the procedure in the ACCC. With the conclusions during the discussions, we already appealed against these license changes, both in 2015 and in 2018. So we went to court, and we lost there again. What we argued there was with the argumentation that was developing in the ACCC, but the Council of State did not accept that argumentation because they said, well, there are no findings yet, and there will only be confirmed in the meeting of parties somewhere in the future, and only then we can look at it, and until that time we don't want to look into ours. The result was that we communicated that back to the Irish Compliance Committee and said, well, on the basis of Article 610, which talks about extensions and updates, these two licenses are updates, and there is still no environmental impact assessment that covers this period. So these license changes have also been made without proper public participation and without the information from the public participation. So we think that it is still in non-compliance with the convention. And the Compliance Commission then said, well, the thing is, we talked in case 104, the earlier case, only about the duration of operation and not about other extensions and updates. And we would like to be very precise if we talk about when is this appropriate to have public participation. So we will not discuss it in the ongoing case, which was the 104 case, but you are, of course, open to file another case on the two license changes, and we will look at those cases then, which is what we did in 2021. We filed case 187, it was admitted, and that is still ongoing. In the meantime, the Compliance Committee in 2019 has come with its findings, and the Netherlands started changing its legislation, but only focused on the duration of operation. They also said Yes, but this case was only about the duration. And if there are other cases of extensions and updates under Article 610, then we don't have to do it now because the ACCC has not told us to do so. I think that that's pretty stupid. I think that if you see that there is a problem with international legislation implemented in your own legislation, it's better to deal with it up front than to deal with it afterwards. But okay, that's the situation we're in. There is a second problem, and that is that the change in legislation does not assure public participation on the environment. We saw it in the license changes from 2015 and 2018. When we came with argumentation on the environment, there was a public participation procedure. Also in 2013, there was a public participation procedure, but all our arguments on environment were dismissed as not being relevant. Now, that is a very fundamental mistake, because the Aarhus Convention is not just on public participation, whatever, but it's public participation on the environment. So there must be information provided on the environment, that's Article 6.6, which also defines what kind of information. And if that information is not provided and remarks relating to that information is not taken into due account, a country is in non-compliance with the Aarhus Convention. So the ACCC has failed to find the Netherlands in compliance, even with its proposal for this new legislation. And it has advised that, that the Dutch authorities start communication with us as communicants. Now, that may be starting. The Netherlands already had one discussion with us about their action plan, how to implement the findings of the compliance committee, but it did not dare to look to the wider issue of Article 610, and also not in the general sense of how does this relate also to the Espoo Convention and to the European directives. So we have a start of a conversation, but it's still got a way to go. What is important here is for you to notice is that during the last meeting of parties, Priska already referred to it a moment ago, is that the ACCC also proposed general findings on compliance. Those are general conclusions which are building up all the cases that it has dealt with over the last 20 odd years. And in these general findings, you find a lot of very interesting stuff for whatever you're working upon. But what is important for us, it has two paragraphs, paragraphs 63 and 64, which are dealing with periodic safety reviews. And the ACCC clearly states there that 10-yearly periodic safety reviews have to be preceded by public participation on the environment, according to Article 6. And that means that for Borselen, we now also are looking to how the Netherlands are going to do that public participation before the upcoming 10-yearly periodic safety review in 2023. The authority responsible for that, which is the regulatory authority in the Netherlands, ANVS, has already taken up contact with us as communicants, as was also advised by the ACCC, to see how that public participation should look like. What we have advised is make it look like an environmental impact assessment, because that is the only procedure which is already embedded in Dutch law. It makes it easier if you do it that way. And it will cover also all the information that is that needs to be provided under Article 6.6 of the Aarhus Convention. So far for Borselen, for the moment. The second case where I want to draw your attention to is a case that has started a few years ago, which is the case of Tricastin in in France. Tricastin is the first nuclear power station in France that needs, or that is going beyond its 40 years operation time. And in principle, this will be the first of about 30 reactors to come in the next decade. So it is really setting the scene for what is going to happen in France. Now, France refuses to carry out an environmental impact assessment and severely limits the participation of the public in the procedures before that they take a decision. It, for instance, only allows citizens from municipalities directly around the nuclear power station to participate. What we did as Greenpeace was that we sent a letter to the operator, EDF, to the Ministry of Environment, and to the authority, which is ASN, that an environmental impact assessment was needed. And we asked them, when are you going to do it? And we want an answer within 3 weeks. We then got a response which said, well, we're not going to do it. And after that, we took the 2 steps that you need to take to go further. Priska already indicated that the Espoo Convention and the Aarhus Convention are different in the way that they operate with communications and complaints. The Espoo Convention implementation committee can be addressed directly because it is not about my right as a person. It is about the general obligation from a party to fulfill the convention. And therefore you can, and we did, in a case where it was clear that France was not going to do an environmental impact assessment, we can already, and we did already inform the Espoo Implementation Committee of that fact, and the Espoo Implementation Committee took it up as a case to investigate, and we had to deliver, as Patricia already mentioned, a lot of information to the Implementation Committee explaining how the situation was. But that is now under investigation. For the Aarhus Convention, you first have to look for local remedy because it is about your own rights. So you first have to take all the legal steps that you can take to get your rights. That means that you first have to go to court. We are now preparing court cases in France on this case, the lack of environmental impact assessment or public participation for a wider public as obliged by the Aarhus Convention. We've sent these letters, and on the basis of these letters, we've been able to file a complaint to court. Now, that will take some time still, and I do not know what the outcome will be. I think for the next 4 or 5 years, we'll be busy with that. But in the end, I'm convinced that also France will have to carry out environmental impact assessments before their decisions post 40 years for their entire fleet. Okay. If it is not settled in court, we plan to escalate to the ACCC. That is also what will take quite some time still. Now, the conclusions for me. With Borselen, we have set jurisprudence for the obligation on public participation on the environment before nuclear lifetime decisions. And that includes 10-year periodic safety reviews. That is just a hard conclusion. And it is also my conclusion that if you are in a situation of a nuclear lifetime extension, do go to court, lose there, and go to the Aarhus Convention Compliance Committee. The Aarhus Convention is clearer about your rights on being able to participate in these kind of decisions than the Espoo Convention is. On the other hand, I think it makes sense to also directly, if you do not have an environmental impact assessment, inform the Implementation Committee of the Espoo Convention and put all your effort in it to give them the information that they require, because I think that the power of the Espoo Convention, together with the European directives, is much stronger in courts and is much stronger towards authorities than is the power of the Aarhus Convention. You have less control over what is happening under the Espoo Convention. It's all behind closed doors. So you have no idea what's going on. You only get questions. You never get answers. You never get an update. But we've seen it in the case of Ukraine at the moment that the implementation committee does come with findings and they are endorsed by all the parties. Authorities tend to follow up more carefully than in the case of the Aarhus Convention. On the other hand, in the Aarhus Convention, you're more likely to get what you need and you have more control over the procedure. With Tricastin, what we hope is that we will set their jurisprudence in France for the entire French fleet. And with that, I would like to thank you for your attention and I'm open for questions after the last presentation.
Yeah, thank you very much. This was really very interesting also how to use the different conventions. I think this is very important for us to understand the differences. We have now Gabriele Mraz. She's been involved in many, most likely all environmental impact assessments in the past years, also those on plaques, and will report to us the difficulties she encountered. Gabi?
Yes,
Yeah.
I will share my presentation. Does it work?
Yes.
Okay, thanks. We have already heard a lot today about the importance to have an environmental impact assessment for lifetime extensions and how to make sure that we have an EIA that it is conducted. And what I want to add are some aspects about the quality of this environmental impact assessment if it is conducted at last. I have listed here the EIA procedures for lifetime extensions that have been conducted or have started in Europe in the last years. The most recent one is the Krishko lifetime extension that started this year. Then in Ukraine, we saw the lifetime extension procedures for Zaporozhye 1 to 6 and South Ukraine 1 to 3. I have here 2 dates because in many countries, this procedure started in 2015 and in Austria, it started in 2021. We have the procedure in Finland for the Loviisa 1 and 2 reactors, lifetime extension, then the dual 1 and 2 case. Again, Ukraine, the Rivne case that has been mentioned sometimes before today, that started in 2017. And yeah, the PACS 1 to 4 procedure, this was not under the guidance. This was before. This was a voluntary procedure in 2005. Well, you see this list is not too long. In Europe, we have about 120 NPPs that are older than 30 years. And for many of those, a lifetime extension is planned or has even been made without environmental impact assessment. This is not the most recent number, but in 2020, there have been active complaint cases in the Espoo Convention on 55 reactors at 16 sites. So you get an idea about the number. In my short talk, I want to focus on 2 aspects of quality of an environmental impact assessment. The first is the timing. Priska mentioned it before, that the timing, the EIA has to be conducted when all options are open. And it should be finished before a decision on a lifetime extension is taken. And the results of the environmental impact assessment, they have to be considered in this decision. So what I want to focus on is the question, has it been undertaken early enough so that it's even possible to include the results in the decision? and is a formal procedure established to take the results from the environmental impact assessments into account at all. And the second aspect I want to focus on today is the question of nuclear security. Is this included in the ongoing transboundary environmental impact assessments? So my first example is the procedure on the dual 1 and 2 reactors in Belgium. Their lifetime has been extended in 2015 until 2025 via the so-called nuclear phase-out law. And this law had to be annulled in 2020 due to the ruling of the Belgian Constitutional Court. But the law's effect is maintained until a new law will be enforced to ensure the supply security in Belgium. It also has been said that this environmental impact assessment has to be completed until the end of this year, 2022. Austria participated in this transboundary environmental impact assessment, and during the bilateral consultations the Belgium and the Austrian side had, it was confirmed that the results of this environmental impact assessment will be taken into account for the revised version of the nuclear phase-out law. But it remained unclear in which manner this will take place, and also it remained unclear how and when the results of the EIA, for example, for safety upgrades, will be taken into account in the periodic safety reviews, especially before this nuclear phase-out law will be amended, before this amendment will be approved. Therefore, it can be summarized what is clear, that this environmental impact assessment was not conducted early enough. We knew that, but it is not clear how the results of the environmental impact assessment will be taken into account. And I think this is an important point, because otherwise it doesn't make sense to have this procedure at all if the results are not taken up. Second example, the lifetime extension of Rivne, Rovno 1 and 2. Their lifetime has been extended in the year 2010 for 20 years. We have heard about it without the environmental impact assessment, and due to the decision in the Espoo Convention, the impact assessment has to be conducted before the periodic safety review of 2020. But we saw that the latest decision on the license amendment already took place after this PSR in 2020. So now we have the situation that the environmental impact assessment is not finished, but the licensing procedures are completed. In December 2020, the MOP, the meeting of the parties to the Espoo Convention, asked Ukraine to revise its final decision on the lifetime extension of Rivne 1 and 2, taking due account of the outcomes of the EIA procedure. Again, we had bilateral consultations between the Ukrainian and the Austrian side during this transboundary EIA, and this was one of our questions. How will the results of the EIA be considered? Will these decisions be revised, or is this not foreseen? And we couldn't find it out. We could not clarify when and how the results of the EIA will be taken into account. So we might come to the situation that they will not be taken into account at all. And another example, the ongoing procedure for Zaporozhye, which started in Austria in 2021, as I mentioned before, in other countries already in 2015. Other countries had public consultations in 2017. You know, Zaporozhye has 6 units. Of those, 5 already received their license for a lifetime extension between 2016 until 2021 for Unit 5. Unit 6 is still in the original 30-year operation period, which will end in 2026. In bilateral consultations, again, we asked if the results will be taken into account, and the answer was that, yeah, they will be reviewed by the responsible authorities, but again, it's not clear if this review will also include the already issued operation licenses for the lifetime extensions of units 1 to 5. A short look on good practice. The Lovísa environmental impact assessment started early enough. So in this procedure, it is possible that results of the EIA will be taken into account before a license for a lifetime extension is issued. Also, the Kruško procedure, they do not have so much time like in Finland, but it is possible. My second aspect is nuclear security. For years, we have mentioned that terrorist attacks and attacks of sabotage can have significant impacts on nuclear facilities and, of course, can cause severe accidents. And especially since 9/11, the protection of nuclear power plants against deliberate crashes of large airliners should be considered, and also should be considered in an environmental impact assessment for lifetime extension. What helps to assess the security state of a nuclear plant is the Nuclear Threat Initiative. I provided you with the link here. This is an initiative that analyzes the security status of countries by giving scores for a lot of security relevant topics, among those cybersecurity and insider threat prevention. Also, it's helpful to look at the outcomes of the missions of the IPAS, the International Physical Protection Advisory Service of the IAEA, that makes missions and peer review missions in countries assessing security status. When we look at the ongoing environmental impact assessment procedures, it can be considered good practice if in an EIA report it is explained that security arrangements exist and what security arrangements exist and if they are further developed and especially if they are practiced. This has been the case in the Lovísa procedure. And also it's a good practice to discuss results of the IPAS mission. And that practice, on the other hand, is if the environmental impact assessment does not focus at all on security issues, like it was the case in the procedures of the Ukrainian NPPs. And also to date, no IPAS mission has been conducted in Ukraine. Of course, Ukraine now has other problems than these aspects, but again, I want to say that nuclear security is an important topic and we have to focus on it if an environmental impact assessment is conducted. So my conclusions that many or even most of the old MPPs were never subjected to an environmental impact assessment in their life because they have been constructed before the EIA laws came into force. And now some countries, especially France and Czech Republic, they try to avoid conducting an environmental impact assessment for their lifetime extensions. But besides this, the quality of the procedures is also of importance. So NGOs should ask for environmental impact assessment for lifetime extensions really early to ensure that the EIA will be completed or can be completed before the extension permit will be granted. And it's also important to control that the results of the EIA, if it's finished, will be taken into proper account in the decision of the lifetime extension. It's up to the parties in an EIA to demand that nuclear security questions are included seriously, since the parties of origin tend to avoid this. And like Patricia also said before, to make complaints to the Espoo implementation committee possible, it's important to collect documentations on those issues. Thank you.
Yeah, thank you, Gabi, for the overview from reality. But what occurred to me, I have to admit now, is yeah, there's this, as you said, there is what they hand in, and then what the neighboring countries demand. And but has there ever been the case that some of those complaints or issues or requirements really were taken up from the country of origin and something added or changed? I mean, this is a little bit the question from the result side, so to speak. There's no one who really wants to answer this, is my feeling.
Yeah, this is difficult to answer. We all know that most efforts lead to nothing, but nevertheless, yeah, if there is a possibility to participate, then we should do it, and we should make sure that it's heard and it's considered in the relevant decisions. Because if it's not, then it doesn't make any sense.
Yeah, but it looks a little bit like this. I think it's not the place now, but we should be able to communicate those deficiencies more. That you always, I mean, it's obvious where they are. It's all those security issues that you mentioned. Now we can assume most old nuclear power plants don't fulfill, yeah, and certain threats. So it would be nice to think about how to use this more, you know, to make a kind of blacklist of all those that were lifetime extended, in spite of, as Martin explained before, actually, they should be, so to speak, re-licensed according to the state of the art now, and not some kind of unclear safety level from somewhere in between. Yeah, so at best, I think it usually they arrive at keeping a certain kind of standard they had 30 years ago, to, so to speak, make up for the aging, but nothing more. It's I think never been heard of that they really increase the safety standard, although they claim they are doing that. So it would be a little bit, I think, a task to use this more. Jan, you volunteer on answering this.
Well, there's two important points for me. There is, first of all, we have in the last 2 decades mainly been focusing on the fact that the procedure of an environmental impact assessment was not taken seriously. And we went to court on those procedural issues, and we were winning and winning and winning. So the procedure is now slowly getting better into place. What we've not have had the opportunity to do is to go on what Gabi said, the quality. That means on the content of the environmental impact assessment. And the environmental impact assessments I've been involved in, not only of lifetime extension, but also of new build and strategic environmental assessments of national nuclear plants. We've time and again found that the content is not really up to scratch. The few cases that I was able to bring that forward, we were not able to bring it to the last instance of legal remedy. And I think that is a bit of a problem. That was in Lithuania, was in Poland. In Lithuania, we couldn't do it because our lawyer forgot to appeal. I don't think he forgot to appeal. I think he was forced not to appeal. In Poland, the problem was that a plan, because it was about the strategic environmental assessment on new nuclear power stations, plans, you could not appeal on plans. It was just not impossible to appeal on plans. Mm-hmm. And no, the plan is not a decision by an authority, and therefore the administrative court threw us out 3 times with a lot of costs to say, well, you should not be with us because this is a plan and we cannot decide about plans. And that hampered us enormously to get these questions of content also assessed for a court. I think we should just wait for the next possible occasion that we can do it. If we have an environmental impact assessment like Lovisa, which is procedurally going quite well, but where we are not satisfied with part of the content, for instance, because it doesn't contain a zero alternative scenario or other scenarios we have asked for. Under ARUS, we know on the basis of these general findings on compliance, we know that if we as public ask for certain scenarios, the authority at least must come with a reasoned answer not to include them or must take them over. So that is something we need to do in the upcoming environmental impact assessments. And if we don't get it properly, we should go towards towards court, lose there, go and escalate it to the conventions, and it will take time. But I do think that we can improve the quality of these procedures that way on the longer run. Better would be, of course, if we see and enable the procedures already to run better when they are implemented. Just try to do what you can. It does work every now and then. I mean, one of the cases where we've seen it working is the whole discussions that we had around cooling of the PAX-2 nuclear power station, where there were no proper plans for cooling. The plans for cooling that there were very bad. And the nuclear regulator has forced the PAX-2 power station to come up with better plans. They aren't there yet, but at least we saw that it had an effect there. And I think that you should not underestimate the dynamic that you trigger with bringing forward certain issues time and again. At a certain moment, the dam will breach. Christine asked here on the chat whether there is anybody with a mandate to oversee that. Well, the IAEA definitely does not have a mandate to oversee anything. The International Atomic Energy Agency has a mandate to promote nuclear power, and in that mandate, it has cooperated with all the member states of the IAEA and came up with lots of guidelines and advisories, but they're all advisory. The IAEA does not have any body or any institution to force the parties in the IAEA to conform to these things. On the other hand, we have the Convention on Nuclear Safety, where, of course, the convention parties have a possibility during the convention to say to people who do not comply with the convention itself, you're not in line, and we can now take punitive steps if you don't do it, etc., like in any convention. But it's not a police person. There is no police force. There is nobody. The ultimate authority to oversee that the nuclear power station operator does what it should do is the national regulator. The national regulator in every country. And the quality of national regulators in different countries is very different. We do see that if you have a good nuclear regulator, which has good input also from the public, like in France, that changes are possible. And that they are, for instance, upping the bar of what they consider acceptable risk. Not to the level that we want to, but at least into the right direction. The same in Finland. So okay. I think that we should be very careful not to expect too much from the International Atomic Energy Agency. Even in Ukraine, Mr. Grossi could speak now for over a month already. He will go there, he will go there, he will go to Chernobyl. There is not one person from the IAEA in Chernobyl yet. They have already had 3 weeks to go there. He can't get it organized. And one of the reasons is that he's held back by one of the parties, which is called Russia.
Yeah, okay, it's certainly not the IAEA, but I would like to stay with what we started, unless there is something else, because now we have Krishko, yeah. So this started now, and for example, the concerning the seismic assessments and the seismological studies, there is already obvious that they're using older data. So we all, of course, ask them to please use a new one and assess how the nuclear power plant would react to it, whether it's robust enough to those newly assessed much higher seismological hazards that we see right now. And as if we assume it goes the way it usually goes, there will be some kind of answers. It's not done now, it could be done later, it's not necessary, and so on and so on. And now is the question, what could we do? Because I think exactly as Jan said, we should jump somehow to the next step to go into the content. And if it's something as clear cut as we see that's coming up now with Krishko, I would wonder, can we then complain to the implementation committee on content? And it looked like it's not, no, I'm just saying what our experts, we also have others here, think about this here. It could be kind of easy. And coming back to Lovísa, which was already mentioned, I looked into this, what was written. I understand they largely fulfilled things, but I don't think that they fulfilled all the requirements concerning licensing it to the state-of-the-art safety levels. I would assume this is not the case. How could we imagine to proceed with this? So it's two questions. One is Krishko, which could be kind of easier, I think, and then Lovísa.
Gabi, Martin?
Oh, I'm not sure how to answer this. I would like to ask Priska about
Yes.
yeah, about the Espoo Convention. What possibilities do we have if we want to complain on the content of an environmental impact assessment procedure?
Well, the thing is that usually the Aarhus Convention Compliance Committee, as well as the Espoo Implementation Committee, they don't like to go deep into the details when it comes to technical data. They want to hear about procedural shortcomings. But what we can say, of course, is when it is clear that comments are not taken into account sufficiently, or that within the procedure there is not sufficient room to submit comments, then this is something that can be complained about. Regarding Lovísa, yeah, it's I'm thinking now. I mean, I think it really needs to be considered what the procedural criticism is in this area.
So you think what we have on Krishko, where they might not deliver the newest data and compare, so to speak, to the status of the plant, this could almost be procedural because they ignore the comment. We could try with this.
Yeah, so if it's clear that the comments were not taken into account, that this can be sufficiently proven, then yes, I mean, that's the point. If you have a procedure in front of the Espoo Implementation Committee, the parties also have to defend themselves and prove how they proceeded within their assessment. And this is also maybe from a political aspect very important, that they are forced to open up and to talk. To talk to the Espoo Implementation Committee about their procedures. It's already quite puts pressure on them. No?
Yeah, Tony,
just a very short distraction back to the process. I mean, we joked about this situation in Croatia, but I would really like to hear some thoughts. So I have written formal response from the Ministry of Interior. Explanation is that in 2019, Croatian government closed National Regulatory Agency and included it as a department in the Ministry of Interior. So Ministry of Interior responded to me that Croatia officially applied to participate in a process, that on the 1st of March, Croatian institutions received Slovenian study on environmental impact assessment, and they cannot tell me when there will be public consultations and when the kind of expert committee will be established, which will articulate comments on behalf of, I guess, of Croatian government. I don't know. So, I mean, what kind of legal situation we have in hand if Croatia don't implement procedure of participating in a transboundary environmental impact assessment? And did we ever had such a case before? Thanks.
I can pick that up and then put my question afterwards, Patricia. It's easy, Tony. There's two ways. First of all, you have witnessed non-compliance with the Espoo Convention. That means that it is sufficient for you to write a letter with argumentation towards the implementation committee of the Espoo Convention and ask the implementation committee to oversee proper implementation by Croatia. That will, the IC will look at it, will then decide whether they take it up. If they take it up, they will open a case. That is what you can do now. The other thing is, if you feel this is important, bring this to court. What you need for that is probably a certain kind of decision from somebody in an authority, but be creative in finding a decision and then appeal that decision in court with that argumentation. You need to go to court first. You need to be thrown out of court first before you can go to the Irish Convention Compliance Committee. So it doesn't matter whether you win or lose in court. That is one of the biggest mistakes made by lawyers that are dealing with these kind of issues. That is that they say, yes, but we don't go to court because we will lose there, it makes us look bad. And you say, yes, but I don't care whether I lose because I want to escalate it. I need to go through here still. It's especially a problem in Hungary where lawyers really don't dare it. But there is also other countries where that happens. So insist on going to court. It costs you a little bit. You're not in the United Kingdom. It will not cost you your house. And lose them and then indeed escalate it. I mean, that is the thing, how you can do it. On the question of from Patricia, on content, I think the finding in the general findings on compliance from the ACCC, or the conclusion that you need to consider or argue why you have dismissed alternatives that are brought forward by the public during public participation is one of these content things. It's not procedural, it's really about the content. What kind of alternatives need to be in the public participation? And the ACC said, well, it's clear, there needs to be some kind of a 0-1. And if it's not in there and the public has asked for it, you'd be in a very, very difficult position to argue that you did not look at it. I think if you read the general findings of compliance, you'll find more things that are related to content, not especially to content for nuclear, but there are a lot of examples where the ACCC has lifted out conclusions on lack of content based on Article 6.6, so the content of what was delivered or how content was taken into due account in general findings that are applicable for all. And remember, these findings have been adopted unanimously. There is no country that can say we didn't know. I have to be very honest, most countries weren't in the room and they just let it go. And they haven't really negotiated it in the European group. I don't know why that is, because I think there are a lot of contentious issues in it, but it was unanimously accepted, so it's standing very, very strong. Read those general findings on compliance. It's fun to read it, and you'll learn a lot out of it.
Okay, thank you, Priska.
I just wanted to add something regarding the situation in Croatia. because this is, since we have a little bit of a triangle situation here, that Croatia is not able to provide or does not provide information on the procedure. And the other question is whether it's not able to provide information on the procedure because it doesn't receive the information from Slovenia. So I think this is a little bit of the question, and what needs also a bit maybe more investigation before submitting a complaint to the Espoo Implementation Committee, against which state you complain in this case, you know. So, but I agree with Jan that it makes also sense to start a national procedure. It could be started with a formal request for environmental information, because the information on this assessment procedure is environmental information, and then it could be taken to court easily. Yes.
And it's a definite win at the level of the ACCC. I mean, that's just a nice thing of it. It will take you 5 years, but you'll get there and you'll win.
Okay, Reinhard.
Thanks very much for your presentations. I've got a very theoretical question. Well, we do this for a reason, obviously. For a theoretical question for something totally unthinkable in the context of the Krishko environmental impact assessment. If for some reason in the process it comes up, they have to do a safety upgrade. In theory, this could happen. Who actually decides on this? Is this the body that's actually doing the environmental impact assessment, i.e. the Slovenian Environmental Ministry? Or is it the nuclear regulator? Obviously, as he or she is responsible for safety, but who tells them to do it? Is it the ministry who tells the regulator to do it?
This is pretty straightforward. The ministry is responsible for the procedure, but the deciding authority is the one who needs to take the findings into due account. So that is, in this case, is the SNRA, the regulator, who then needs to take that further towards the, and it's also because it's also a license issue. He needs to take it up in the conditions for license in one way or another.
Yeah, can I think, I don't know, I'm not, yes, that's the obvious answer. I still, if we now stay with these seismological issues, yes, where Kutbecker said clearly, this is old, they have to make newer ones, and those, or they have the results and they didn't, so to speak, apply them on the nuclear power plant. So then, of course, the regulator, as you say, they are responsible. They could say, oh, we consider it all fine, it's not necessary. But if now we go back to what I asked before, that the ministry, which is, as you say, also they're responsible for the procedure, for the whole thing, say, aha, to us it looks like we need the new data, and they ask the nuclear authority to do this. I'm not so sure this is clear, and I think this time we should go and try. I don't know how
sue both, then sue both.
Yeah,
and
no,
let
but
the
I'm
judge decide.
Yeah, but from the logic, I don't see it this time that it's only up to the nuclear regulator. Yeah, we will. Yeah, bitte, Priska.
Maybe just to add on to this, I'm not so familiar with the national procedural law in Slovenia, so I can't say that for sure. But generally, what is taken into account in the environmental impact assessment procedure is everything that has potential effects on the environment. So if it is clear that the safety upgrade has environmental impact, and I would say so, yes, then it should be considered in the EIA procedure. Of course, yes, as I said, I don't know in which order these procedures take place, and if the nuclear regulator already, yes, but the specifics at which point the nuclear regulator already decided on this issue, and the EIA authority just is able to take this decision already taken into account, or needs to needs to gather new information on this. That's a little bit also depending on the Slovenian law in this case.
Priska, that there needs to be argumentation from the authority, whoever the authority is, on why they did not take up your suggestion, your point of view. And if that is blatantly insufficient, I mean, then we get to Patricia's point, we need to start suing. We need to go to court. And the question of Reinhard is very current there. Who do you sue at that moment? Do you sue the one who is responsible for answering these questions, for giving a bullshit answer and saying, well, therefore it's not taken into your account? I would say the argumentation. Yeah, I'm just now thinking loudly. Yeah, I think if your viewpoints have not been taken into due account, Article 6.8, you will have to take to court, first of all, the ministry. That's true. Yeah. But I do think that it is also important to take to court the regulator for not securing obvious failures of safety. And that's another procedure, and that's going to be technically maybe more complex procedure. But that's, therefore, I'd love to help there.
Yeah, I think we have to, as I said before, we have to keep collecting documentation concerning exactly this, that they were asked, they ignored it. And I mean, it's clearly for Espoo implementation, it's the ministry's job. And if we have something, so to speak, so simple, where we get out of the safety discussion, it could be opening the door. And I'm not so sure we really need to have to wait then for the safety regulator to chew over it and produce some weird studies saying that nothing really changed and they come with new codes and calculation and all that. But the question is whether at this point already, when they end and they ignore this, we can already complain to the implementation committee. I think that's we have Albena, who also wanted to ask something. Hi, Albena. Albena? Yeah, we can see whether
we should be able to hear you now, Albena.
I think. Do you hear me?
Hi.
Sorry. Okay, can you hear me now?
Yes, yes.
I understand that if somebody decides, especially in Eastern Europe, countries more or less are deciding not to make environmental impact assessment. Like, it was Kozloduy 5 and Kozloduy 6 lifetime extension. Even though if Romanians are complaining or neighboring countries are complaining, the authorities do not take into account those kind of complaints. The control from European Union is very weak. I mean, from European regulator is very weak. Or nothing happens. I can see now what is happening with the building of nuclear waste disposal.
Albena, can we, for a minute, stay with what you said? That's of course completely correct, that Kozloduy decided with the government, decided they don't need a Plex. But as I sent out a rather urgent request, the Romanian NGO, which back then complained to the implementation committee with this long name, have you seen it? I wrote it to you on Facebook and I asked them on Jux list.
Yes.
We would kind of need them because there might be reactions from the implementation committee coming at some point, but they don't exist anymore. So it would be very helpful.
A lot of Romanian NGOs do not exist anymore. The same is happening, with Bulgarian. You see,
I know that.
Ukraine, with Ukrainian, we don't have connections. We are trying to find our friends from Ukraine now. Another topic. What are we doing in a case of war?
Yeah, but let's stay with this implementation committee. So you also think these Romanians don't exist anymore. So we have a problem that someone who complained And again, after years, the implementation committee comes back to it and they don't exist anymore. I don't know, Priska, whether you have any answer on that.
Yeah. Anyway, there are another NGOs from Romania which are more or less reliable, but
yes, more or less,
yeah.
yeah. But the problem is those now with the long name back then raised the issue and now they disappeared. So that's now the biggest problem with what you raised. I don't know how we get out of this. Gabi wanted to say something and then Jan.
Oh, yes, I wanted to come back on Crisco one more time, because I wanted to coordinate a little bit if there are any public hearings, because public hearings are also a good opportunity to make documentation of answers to requests or to questions, which can be used afterwards. And I want to inform you that there will be a public hearing in Austria on the 19th of May in Graz. But I wanted to ask you if you know from any other hearing, not in Croatia, as it seems, where it definitely should be. But I don't know if Martina is still here. No. Do you know anything from other countries?
She wrote that she doesn't even, she wrote to the wrong ministry, Martina. I answered to her already. So
okay,
she won't know
okay.
anything of this right now.
Okay.
Thank you. I have Jan wanted to, can you make a quick reply? Because Marcin said he wanted to raise a question. I have not properly understood it. Perhaps Marcin, you could after Jan
I pass.
say what you wanted to know. Sorry? Aha, okay, great. Marcin, I haven't understood your question, I have to admit.
Okay, it can be simplified. Are
Please.
any generic security issues taken into account in the procedures, and somehow how are they communicated? Perhaps I should add, perhaps in the report on the license, on the eventual report on the or in the license perhaps. But basically, how are the security issues dealt with?
You mean?
The answer on that is that as such, the authorities responsible for security are in many countries different authorities than the nuclear regulator. In some countries, it's the same authority. You would have to figure it out per case, whether the nuclear regulator has a mandate on nuclear security or not. In many countries, they do not. There is other authorities. But in the case of environmental impact assessments, issues of security have also relevance for impact on the environment. And with that, they fall under the Aarhus Convention and they fall even under the Espoo Convention, which means in an environmental impact assessment, you can ask questions about and can raise viewpoints on security issues that will normally spoken not be dealt with in an environmental impact assessment. But you can raise them and they need to take your input into due account, which means you need to get an answer on them. Of course, there will be certain issues which they will not answer for security reasons. That falls also under the exemptions on access to information that you get under Aarhus and under the directives. So for instance, they will not show you how many security personnel they will have on a nuclear site. They will also not tell you whether in case of war, there is a provision that anti-air craft weapons will be put around the nuclear power station. They will not give you that information. But you do have the right to ask questions and bring up viewpoints.
Okay, thank you. That's so interesting. Albena? Albena, are you here? Do you hear us? You raised your hand, or is this the old hand raised?
Not me, but I wanted to finish just to tell something to Jan. We are ready, to go in the court if something happens. But not for first time, of course, with your experience, even how much is the cost of these lawsuits there? More or less, the complaints are coming from NGOs, from civil society, which could not allow the court taxes or whatever. Then what we can do in that case?
You would have to come with an estimate of how much the court costs are. If you really deem them too high, then you could bring that as a direct complaint to the compliance committee under Aarhus, because in the Aarhus Convention, under the Aarhus Convention, it's not allowed to make access to justice under Article 9.3 inaccessible by too high court fees. So it would make sense to try that, although the ACCC has jurisprudence that citizens can be expected to pay a certain amount for court procedures, and in some Western countries that has been accepted as being quite high. So the court fees that I have to pay are definitely court fees that I should be able to pay, that I should be able to crowd fundraise, for instance. In the United Kingdom, it is an ongoing struggle, and there is still an ongoing debate between the ACCC and the United Kingdom on whether access to court for citizens is warranted there because of the high cost. Maybe Priska can give there a bit more detail on that.
Yes, maybe just to add on to that, there is in fact a quite strict approach of the Aarhus Convention Compliance Committee when it comes to court fees and direct costs related to court trials and access to justice. What of course is a practical issue for all NGOs, I would say in all countries, is the question of representation by attorneys, which is also connected to costs. And this is usually accepted by the Aarhus Convention Compliance Committee that NGOs need to be represented, and that this is related to costs which are obviously also quite high and can be a burden. So this is a little bit of an issue, I would say, that we are also facing in Austria. Yeah.
But Albena, I would say just prepare a communication to the Aarhus Convention Compliance Committee on the issue. On the top of my head, you'd have to look at Article 9.3. I'm not looking at Priska directly in the eyes, but I think it's 9.3. It's somewhere at 9 in Article 9. 9.4. There we are. It's in 9.4. Look at the Aarhus Convention itself, how it's formulated, and then use the form which is on the website of the Aarhus Convention Compliance Committee to make your communication.
Okay. Anything else? The big quiet. Yeah, so if this is okay, is there anyone also from the speakers in particular who would like to say something before we leave this meeting? I think it was very interesting, very helpful, and I think we also got new ideas how to continue. Somehow the next level could be reached. Anyone wants to add something on this, or is this the last words and we can finish a bit early? Okay, so everyone is happy. So thanks very much mainly to the speakers for the excellent presentations, and I think really interesting discussions which helped us a lot. We recorded everything, and I think with Gabi we could think about where to use it. Perhaps we send it also to you so that you spread it via your channels. I think it's extremely helpful. It's yeah, for those who want to enter this game. I would like to have it on YouTube, because I have the feeling there is also a lot of pro-nuclear information flying around. So we should try to put our discussions there too, because they're very helpful and not pro-nuclear. So thank you very much and have a nice afternoon. Bye. Bye.
Thank you. Bye.
Ciao.
Thanks, Patricia.
Bye everyone. Thanks.
Bye,
Bye,
everyone.
and thank you.
Bye, Malvina. Bye.
Bye.
Thanks.